Welcome to You Texted What? Admissibility of Text Messages at Trial. I'm Lori Cripp Martin, a certified family law specialist and past vice chair of the Beverly Hills Bar Litigation Section. I'm delighted to introduce our speakers, Nabila Hussain and Donald McGilligan. Donald, also known as Duffy McGilligan, is a partner at Cotchett, Petrie, and McCarthy LLP in the firm's San Francisco Bay Area office, where he focuses on complex litigation involving wildfires, wrongful death, and business fraud. A seasoned trial lawyer, he has tried 48 jury trials and honed his courtroom skills during a decade as a prosecutor in Santa Clara and Contra Costa counties, earning multiple recognitions for distinguished service. McGilligan received his JD from the University of San Francisco, where he was a law review member, a Cali Award recipient in torts, and later clerked for the Honorable Maura Corrigan of the Michigan Supreme Court. Our other speaker today is Nabila Hussain, a partner at Cotchett, Petrie, and McCarthy LLP, where she focuses on complex civil litigation, including high-stakes wildfire, consumer class action, and corporate accountability matters. Her work includes prosecuting claims against PG&E arising from the Kincade and Dixie wildfires and securing a $117 million recovery for the Fire Victim Trust, in addition to cash and stock valued at $13.5 billion, as well as representing consumers in class action against major corporations. Prior to joining the firm, Hussain spent 8 years as an assistant district attorney in New York County, trying 19 cases to verdict as a member of the Homicide and Sex Crimes Unit. And she is a frequent lecturer on trial advocacy, evidence, and trauma-informed interviewing. And now for our presentation. Let's get started.
Hi, everybody. Thank you, Lori, for the introduction. So my name is Duffy McGilligan, and I'm a partner with Cotchett, Petrie, and McCarthy in Burlingame. And like Lori said, before I joined Cotchett, Petrie, and McCarthy, I was a prosecutor for 10 years. And as a prosecutor, our bread and butter was text messages. We made a ton of cases with text messages because they're spontaneous and they're great evidence of somebody's mental state. If you think about testimony in a deposition or in court, it's not always the best because the witness is being coached up by their attorney. Even if you can get your hands on emails, people type slower through email than they do through text, so it gives them time to reflect. Whereas text messages are spontaneous. They're great evidence of the person's mental state, and they're typically sent without any reflection. So we love text messages in our cases. They're harder to get in civil cases because of the Electronic Communications Privacy Act. But if we do manage to get our hands on them, we want to make sure that we're able to get them into evidence. So if you have text messages between two parties, those are coming in because the recipient can authenticate them. This presentation is about text messages that are sent to third parties and the special issues with authentication from there. So before I get started talking about a recent California Court of Appeal case, Nabila is going to give a quick refresher about rules of authentication.
Good morning, everyone. My name is Nabila Hussain, and I'm also a partner at Cotchett, Petrie, and McCarthy. I was similarly a prosecutor before I turned to civil law, and I echo Duffy's sentiments about the depth and breadth of the text messages being amazing evidence, especially when you think about what to tell a jury, what weight to give different evidence. Text messages are great because it's spontaneous thought and it's usually sent without any sort of deliberation. And so this is great evidence, and we should learn how to get them in our civil cases. So just as a reminder, why do you have to authenticate your text messages? Well, there's two reasons. Number one, you have to show that the thing is what you say it is, that you have to show both the court and the jury that the evidence hasn't been tampered with, that someone didn't make the text message on ChatGPT, it hasn't been tampered with, it's not altered, or it's not being misrepresented by cutting certain pieces of the text message out. Additionally, you need to authenticate messages in order to put them into evidence. It's a foundational requirement. And how exactly do you authenticate text messages? Well, you can see that in Evidence Code 1400. A text message itself is a writing, and a writing is authenticated under this code. And if you read this code section carefully, you'll see that authentication requires the introduction of evidence that's sufficient to sustain a finding that the writing is what the proponent of the evidence claims it is, or the establishment of such fact by other means provided by the law. What the code doesn't say is that you have to put the writer of the text message in as a sponsoring witness. So you don't have to prove that the text message is what you're saying it is beyond doubt. You're giving both the judge and the jury enough to weigh and believe that the thing is what you say it is. And if the other side has another version of events, that's usually a weight argument, not an admissibility or authentication argument. So that's, a pretty simple thing to do when you have text messages between the parties or by one of the parties sent from someone else. But what do you do in a situation where you have text messages with third parties, such as screenshots? Duffy's going to talk to you about a recent case that addresses this.
So last year, the Second District Court of Appeal issued the opinion in Adoption of XD. And this is a case in family court regarding a contested adoption. So what happened in that case is shortly after the mother found out she was pregnant, the father punched her in the face during an argument. She went to a domestic violence shelter and cut off all communication with the father. 9 months later, the baby's born. She puts the baby up for adoption. The court gives notice to the father of the adoption and he challenges it. So the issue before the trial court was, is the father committed to being a good parent? During the trial, the mother testified about the history of domestic violence between the two of them. The father testified, consistent with how abusers testify, that it was all a big misunderstanding and he was going to change in the future and he was going to be a good father. The key piece of evidence in the case was a screenshot of text messages. And I've focused on one of those text messages here. This is the actual language from the text message that the mother tried to get into evidence. The father had texted, "I hope she die and that baby she carrying die, evil bitch." So obviously this is great evidence for the mother because it shows that the father is not committed to being a great parent if he's hoping that the baby dies. The father naturally moves to exclude the text messages. And the problem that the mother had was the father had not sent this text to the mother. So the mother could not testify that it was a fair and accurate representation of a text that she received. The text was sent from the father to his sister, Ruby, and then the sister forwarded the text to the mother. So when the mother was in court, she had a screenshot of text messages that she says came from the father, but all she could testify to was that they came from the sister. So the evidence at trial, the mother says, sister sends me a text message, but the sister did not testify. And the trial court said, no, that evidence is excluded because you cannot get text messages into evidence unless you have a subscribing witness. This case went up to the Court of Appeal. Court of Appeal said, reversed. This is an abuse of discretion because Evidence Code Section 1411 says the testimony from the subscribing witness is not necessary to authenticate the documents. Now, the Court of Appeal did a great thing. They did not stop there and remand the case back to a judge who clearly didn't understand the evidence code. They gave us a tutorial on how to authenticate these types of messages that come from a third party. And what they focused on was self-authenticating text messages or self-authenticating documents according to Evidence Code Section 1421. So the appellate court looked at the contents of the text messages that the mother was trying to get in. The first thing they looked at was the sender's name. And in the sister's phone, the brother was saved as Lil Big Brother. And during the trial, the father did testify that his sister sometimes calls him Little Big Brother. The next thing the court looked at was the phone number that the text messages came from. And during the trial, the father testified that, yes, that is my phone number. And then finally, the Court of Appeal looked at the content of the text message itself, specifically that in the text message, the sender had accused a woman of cheating on him. And the father had testified at the trial that, yes, he had accused the mother of cheating on him. So what the Court of Appeal said was, look, if you take all this circumstantial evidence, the mother had made a prima facie case of authenticating the text message. She made a prima facie case showing that that text message had in fact come from the father. And the Court of Appeal said the trial court should have let the text messages in. And if they did leave the text messages in, then the trial court should have found that the father was unfit. So it was a total victory for the mother on appeal. If you look at the court's analysis, they focus on three different facts that you need to consider when you're authenticating certain types of documents. Evidence Code Section 1421, which says you don't need a subscribing witness to authenticate. They talked about the Supreme Court case of People versus Goldsmith, which says that you can authenticate documents through witness testimony. And they looked at the case of People versus Valdez, which affirms the concept that you can prove authentication through circumstantial evidence. So the takeaway from the adoption of XD case is, don't forget that you don't need the testimony of the subscribing witness, and be aware of these cases, Goldsmith and Valdez, when you're trying to authenticate documents through circumstantial evidence. So that's the adoption of XD case. Nabila is going to talk a little bit more about authentication rules and text messages in some other well-known cases that you've heard about.
So practically speaking, how this applies to you in your cases is that you have to get ahead of this early. So the myth that you have to kill early with both the judge and the other side is we need the sender, we need the screenshot taker, we need the subscribing witness, we need the drafter. That's absolutely not true. Under Evidence Code 1411, except as provided by the statute, the testimony of a subscribing witness is not required to authenticate a writing. You can authenticate a writing by its contents and circumstances, not just its witness, just not the witness that wrote it. And there are a couple of different ways that you can do this with text messages specifically. This is a menu of options that you have for authentication with text messages and screenshots. As you saw in that Lil Big Brother text message, you can use content clues like nicknames or facts that only the people involved in the text messages would know, or references to events, fights, or plans. There's also this concept of reply authentication, where if you look at a chain of messages, the reply confirms or acknowledges something that the sender sent. And that's something that would only be known between the recipient and the drafter of the text messages within the screenshot. You can also use the device and account clues. You have phone numbers, you have how the actual person is saved in the context of the phone or how other people refer to them, such as Little Big Brother. And if you noticed in that text message, there's a unique style of writing. And if that is something that you can also use to authenticate text messages, the way that the words are written or typed, the style and manner of how it's written and spoken. And then finally, you've got plain old witnesses and circumstances. If the recipient recognizes the sender and the context, if a witness was there live and saw someone writing the text message, you could put that witness on as well to authenticate the text message. If the sender also admits to key parts of the text message or a dispute, or the timing and the location makes sense. So I'm going to show you a couple of examples from criminal cases as to how this applies. And criminal cases are really great to drive this point home, because in a criminal case, a criminal defendant has a Fifth Amendment right not to self-incriminate themselves. And so you can't put the defendant on to authenticate their own text messages. You have to think about how you're going to be able to do that without actually getting the defendant to say, yeah, these are my text messages And yes, I wrote them. So I'm sure everyone remembers the Jennifer Crumbley case. She was tried for manslaughter when her 17-year-old son, Ethan Crumbley, committed a school shooting. And one of the issues in contention during that trial was that Jennifer and her husband and Ethan's father ignored Ethan's mental state and allowed him to have access to guns. And Ethan was obviously tried himself for murder. And so there were text messages between Ethan and his friend, and the prosecution needed to get these text messages into evidence to show that he had a mental state that had been compromised and his mother was ignoring it. So I know these are a little hard to read, but hopefully you'll get the materials. But the text messages from Ethan say things like, I hear people talking to me and I see someone in the distance. I actually asked my dad to take me to the doctor yesterday and to get me some pills, and he told me to suck it up. Like, what is the point that I'm asking to go to the doctor? And my mom laughed when I told her. So, how did the prosecution actually get these text messages into evidence? What they were able to do is put phone records in to show that the messages came from a phone number that was registered to Ethan Crumbley, and that the recipient of the text messages was an individual named Brady, who was a friend of his. And there was testimony throughout the trial that Brady was in fact a friend of his. And this is a reference to the gun. My dad left it out, so I thought, why not? And that's how they were able to successfully get these text messages in. And you can use the same sort of concepts in your civil cases as well, using the circumstances, the way that the contacts are saved within a phone, as well as the subscriber information. And then there is the famous Aaron Hernandez trial from 2015. So Aaron Hernandez and his body man, Ernest Wallace, they were co-defendants in a murder homicide for killing someone named Odin Lloyd. And so you had two people that were exchanging text messages, and you couldn't have either of them authenticate the text messages because they were both defendants in a criminal case. And so the police actually had Aaron Hernandez's phone, and they wanted to establish that the two of them were together that night committing this homicide. So how were they able to do that without either of them being able to testify? Well, they called someone from Sprint. They put a Sprint rep on the stand who bought thousands of pages of cell records, basically, that show the incoming and outgoing text messages and their corresponding times and locations. And what they did was they took the cell phone records and then they paired it up against Aaron Hernandez's actual phone. And they were able to show that the records matched when the text messages were sent and received, and that they were sent to a number that belonged to Ernest Wallace. And throughout the trial, they also heard testimony that Ernest Wallace was known as Fish 2 amongst their group of friends. So that's also a creative way that you can get text messages and using the same sort of context clues and other means of authentication beyond just getting the subscribing witnesses. And so here's a set of text messages that they were able to correspond against the phone records. You'll see that the 2:14 p.m. is there. Me is obviously Aaron Hernandez, and Fish 2 is the person that they were that they were being sent to, and that was his co-defendant. So the bottom line is texts are writing under the code and they need to be authenticated, but you do not need a subscribing witness to authenticate them. You can authenticate text messages, screenshots, or other writings using the content and the circumstances if you don't have a witness. And if the other side wants to argue that it's altered or it's not what we're saying it is, then it's usually a weight, not admissibility argument.
So Nabila, I hear that quite a bit. It goes to weight, not admissibility. What does that mean?
That means that if there is no evidence to challenge that the item is not what you're saying it is, that is a weight argument. So in other words, if you are able to circumstantially establish that the text messages are in fact between two people and there is no evidence to suggest otherwise, then the attorneys are free to go and argue to the jury that these are altered or changed, or we don't know what they are, but it's not an admissibility argument.
And then when you're trying to make your case for authenticating documents, do you have to prove admissibility or what's the standard?
Well, documents themselves are also writings, and the same sort of rules apply, right? That you somehow have to establish that the item is the thing that you say it is.
Yeah. So when you're proving authentication, you just need to make a prima facie case. And the defense is always going to argue that, hey, there's another way that you can interpret these text messages. The the proponent, the proponent's interpretation of the messages is not the only interpretation. And your response to that is, look, that goes to the weight of the evidence, not the admissibility of the evidence. As long as you make your prima facie case that the text messages are what you say they are, they're coming in, and the other side can make the argument that there's some other interpretation. I'm So that's it for authentication of text messages. If you're curious about this, I would read that adoption of XD case, which is a great illustration of some of these issues. Um, I'm going to look at some of the questions in the Q&A. So one of the questions is, and I'll give this to you, I'll tee it up for you, Nabila. What if the party is deceased and you want to enter that party's text messages?
Well, you still have the regular old issues of hearsay, so you have to get beyond those. And if you can do that circumstantially, or I'm sorry, if there's a hearsay exception to the text message that you're trying to get in, then you move on to authentication, and you can use the menu of options that we've already discussed to try to get it in. But you still have a hearsay issue to deal with as a threshold matter.
And, if the defendant is dead, I mean, it's no different from a criminal case where they're invoking their Fifth Amendment right to stay silent. So a lot of these issues, adoption of XD is going to answer a lot of the questions that you're going to have. One of the other questions in the Q&A is, what if the defendant received a message from the complainant? So if it's a bad message for you, I think you're in trouble because all the defendant has to do is say, yes, this is a text message that I received from the plaintiff. The hearsay exception is a statement of a party opponent. So the only way you're going to keep that out is some sort of 352 argument saying that the probative value is substantially outweighed by the risk of prejudice.
Duffy, in that case, what do you do if someone argues, well, I didn't, what if the complainant argues, well, I didn't send that text message?
Yeah, I think the defendant is going to make the same arguments that the mother made in adoption of XD. The defendant's going to say, look, every time I've gotten a text message, it's come from this phone number. The content of the text message is consistent with prior conversations that I've had with the sender. And I think that plaintiff is going to have a hard time keeping that out. Somebody asks, were phone companies subpoenaed in order to prove sources of text messages? So in my experience since joining civil litigation, I have not had luck subpoenaing subpoenaing content of text messages directly from the phone companies. In 2016, California passed the Electronic Communications Privacy Act, which basically said the only way you're getting content of text messages from the phone companies is through a criminal search warrant. So you can subpoena records from the phone companies and they'll give you the subscriber information and things like that. But in my experience, they will not give you the contents of the messages themselves.
And in my experience, they just don't keep the contents. Text messages are too voluminous, and the phone companies don't keep that information on their servers. They're wiped out immediately.
Somebody asks, what if the defendant's lawyer gave the plaintiff text messages in response to discovery without any phone number or name attached to it? Is that admissible? What I would do in that situation, Nicole, is I would probably send requests for admission to authenticate those messages or meet and confer to confirm who they came from. So I would want to sort out that issue well in advance of your trial. because like we talked about, if you can get your hands on these messages, they can be incredible evidence, but you've got to be thinking 2 steps ahead about how you're going to get them into evidence once you get into court. You don't want to be worrying about authenticating them when you're in motions in limine. So somebody asked, what about the hearsay rule? So remember from law school that when you are trying to get evidence in, you have to consider the relevancy, authentication, and hearsay. So all we've been talking about today is authentication. So once you authenticate it, you still need a hearsay exception. So in the case of adoption of XD, the court said that the message comes in for its truth as a statement of party opponent, but the messages also have a non-hearsay purpose, and that is to show the mental state of the sender. Because remember, the issue at the trial was, is he committed to being a father, which is a mens rea question. And the court said that those messages showed his mens rea, that he was not ready to be a committed father because he was making comments about hoping that the baby died.
And in the Jennifer Crumbly case, Ethan Crumbly was not a co-defendant with her in her particular case. And so you couldn't use the party opponent admission hearsay exception rule. So the rule that was used there was then existing mental state to show that Ethan Crumbly was in fact depressed and struggling with mental health issues.
So Walter asked, what if the messages are over an application such as Instagram? So you should run through the exact same analysis that we did for the text messages. If you can get access to the defendant's Instagram, what you do is you take a screenshot of the message you want, as well as the date and the account holder's handle. And then when you're questioning the defendant, they may deny that they posted that. But what you'll want to do is you'll want to ask them, hey, is this your profile name? Is this your profile picture? Do you have an Instagram account? Like, you want to lay all that foundation so that you can prove that it was posted by the defendant through circumstantial evidence. Trenton asked a question about, do the phone companies keep records of who sent what to who and when without providing the content? In my experience, if you send them a subpoena, they're just going to give you the account information. So the account holder's name, account holder's contact information, when the account was opened, and when it was closed, if it was closed, and that they're not going to give you the content even if they have it. They're not going to give you the sent and received details even if they have it, because of the California Electronic Communications Privacy Act.
And in a criminal case, if you wanted to get the records of what was sent, when, and to who, you would actually need a search warrant. So that's not available in civil litigation for the same reasons.
And then Howard asks a question about that we haven't really discussed. I mean, what if the text messages are on your own client's phone and you want persuasive evidence to show the judge? What we've done in the past is we have hired a forensic computer examiner who's qualified to testify as an expert, and we keep chain of custody of the phone. We hand it over to the forensics examiner. They can download the contents of the phone using something called a Celebrite machine, and it creates a report of all the calls, text messages, photos, internet searches, everything that is saved onto that phone will be printed out into a report. And you can have that expert witness testify that the machine that he used to download all the information was working properly at the time, and that he's adequately trained to operate that device. And typically those reports should be admissible. So Geraldine asks a question about text messages between two individuals discussing the case, but it's not to or from any party to the case. So my gut instinct is that's classic hearsay. Um, so you'd have to get creative about how to get those messages in if you can't subpoena those witnesses. And an alternative to hiring a forensic examiner is there are some apps that you can use to download the contents of your client's phones. We do that. We do not use the forensic examiner every time. We will use one of these apps. I think iMazing is the one that we've used in the past. And then it'll create a report of all the contents on the phone. And then the next step for you is you have your client review that report and then authenticate the report saying that it's a fair and accurate representation of the things that are actually saved on his or her phone.
The other way that you could do it is have a paralegal or someone in your office that's not involved in the case do the entire iMazing process, and they could be the sponsoring witness for the report, that they know how to use that program, that they did it correctly, and that this is the printout that came out of the phone.
And then Ashad asked a question about are text messages ever admitted using a statement against interest type approach? Yeah, I mean, once the first step is you've got to authenticate the message. And then the next step is you got to figure out what hearsay exception applies or find some argument to say that it's being used for a non-hearsay purpose. So if there was a statement from a third party that was against that person's own interest, then the declaration against interest hearsay exception should apply. But, when you're going to trial, always remember that there's all kinds of judges out there. Like this family court judge clearly did not have a good grasp of the evidence code. So when you're going to trial, you've always got to have a plan B. So whether that's if you've got a critical piece of information like this, what we'll often do is in our trial brief, we will have a section that lays out the law of authentication to make sure that the judge is making the right decision. But you always want to have a plan B in the event that the judge doesn't agree. So you're going to want to bend over backwards to try and get that sister to come in and authenticate it. So I think we're coming to the end. This is the Beverly Hills Bar Association is going to start experimenting with just 30-minute MCLEs on short topics. So we thank everybody for coming today. We hope you learned something. And if you have any questions, feel free to reach out to Nabila or myself. So thank you, everybody.
Thank you.